Hello and welcome to the Brinks Gilson Lione's 2020 IP Developments webinar. My name is Bailey Reeves and I will be in the background answering any Adobe Connect technical questions. If you experience technical difficulties within the Adobe Connect session, please use the Q&A box on the right-hand side of your screen and our technical assistance team will help in any way possible. If you are having issues hearing over the phone, you may press *0 and an operator will assist you. Please note that as an attendee, you are part of a larger audience. However, to maintain the privacy, the number and names of attendees will not be displayed. All attendees will be in the listen-only mode throughout the presentation, and as a reminder, today's call is being recorded. We will be holding a Q&A session at the conclusion of today's presentation. To submit a question, click on the Q&A panel on the lower right-hand side of your screen. Type your question into the text field and hit send. This seminar is accredited for 1 hour of Illinois' MCLE general credit. Please inquire if you wish to seek CLE accreditation in additional states. During the webinar, we will be providing 3 CLE codes. Please write these down. We will be emailing evaluation forms at the end of the webinar and will ask for these codes. If you have any questions regarding CLE, please contact cle@brinksgilson.com. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce our moderator for today, Gus Siller. Gus, you now have the floor.
Today, I'm going to be moderating a panel of some of our attorneys here. We're going to have a discussion on the issues that have arisen after the Alice decision. I'm Gus Siller. I'm the president of Brinks Gilson Lione. And as I said, we're going to have a discussion of the ramification of the Supreme Court reluctance to grant cert in 101 cases after its Alice decision. We're going to discuss the impact of the court's reluctance on patent litigation and appeals, and we're going to have a discussion by some of our panelists on best practices for strengthening the application process. As I said, our 4 panelists are our own Brinks attorneys. Brinks is a law firm that has been around for 100 years. We're dedicated specifically to IP. We have a passion for the work that we do, our client service, and our team approach. Let me introduce briefly the 4 panelists that we're going to have. Dave Linder. We have 2 teams, a team that's going to be having a discussion on the impact of the Supreme Court's reluctance to grant cert and provide any further guidance, a discussion on the impact in litigation and appeals by Dave Linder. Dave Linder is a partner at the firm who focuses on all aspects of IP protection, including litigation and counseling. He has litigated numerous cases in federal district court and appellate courts. Clients know him for his commitment to practical, efficient solutions that let clients focus on the business initiatives that they have. With him on that team is going to be Andrew Shostel. Andrea is an associate whose practice primarily involves patent litigations in various technology fields, including biomedical devices, computer software, and mechanical inventions. Our second team is going to be leading a discussion on the impact and some practical discussions for the patent application side of the practice. Kent Jenin is going to lead that discussion. Kent is a partner at our firm who has an electrical background. He focuses on counseling and prosecution. He also has extensive experience in assisting clients on developing and managing their portfolios. And Gang Chen. Gang is one of our senior associates. He has a master's and PhD in electrical engineering and physics and helps our clients in litigation, patent portfolio management, and licensing. Prior to joining Brinks, Gang was a senior manager for the IP business group at Alcatel-Lucent for 6 years, where he assisted Alcatel in mining and licensing its patent portfolio. So, as I said, the discussion is going to focus on patentability issues. As you know, 6 years ago, the Supreme Court issued the Alice decision that changed the patent landscape with respect to what subject matter can be patented. Since then, there have been numerous district court and federal circuit decisions addressing the subject matter patentability issue. In addition, the U.S. Patent Office has struggled to provide meaningful guidance on how it approaches this issue. But the Supreme Court has been reluctant to give any further guidance to the courts or the Patent Office on this issue after its Alice decision. So let's get to it. Let me start with Andrea Shostal, who's going to be leading the discussion here on the litigation aspects.
Thank you, Gus.
So before she gets started, I apologize, the first CLE code is Section 101.
Thank you again, Gus. So as Gus mentioned, we're really focusing on Alice today and 101 issues, but I do want to give everyone a brief recap of the state of the law. Essentially, how did we get to where we are today? So the statute that outlines patentability is 35 U.S.C. 101. And the statute itself states that whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefore, subject to the conditions and requirements of this title. Okay, well that's great. But what does that actually mean? And the courts have said that anything under the sun is patentable, except for products of nature, natural phenomena, and abstract ideas. So diving a little bit more into that abstract ideas exception. Again, give us guidance as to abstract ideas are not patentable, but what are they? What is an abstract idea? So starting with the Benson case in 1972, the court stated that the patent in that particular case would wholly preempt a mathematical formula, and it would ultimately be a patent on an algorithm itself. Therefore, it was an unpatentable abstract idea. A few years later, in the Parker v. Fluke case, the Supreme Court again found a mathematical formula and also began speaking on natural phenomena here in this case, was not a patentable subject matter. There has to be some separate inventive concept. And this inventive concept phrase is something that we're going to see popping up again as we dive a little bit more into the case law, so just keep that in mind. And then in the Diamond Chakrabarty case in 1980, the Supreme Court clearly stated that laws of nature, physical phenomena, and abstract ideas have been held not patentable. So jumping about 30 years into the future, we're dealing with the Bilski case in the Supreme Court. And there, the patent subject matter was a method of hedging losses in one segment of an energy industry by making investments in other segments. And in that case, the Supreme Court rejected the machine or transformation test, which had been relied on a lot in these 101 cases previously. But they stated that this isn't the sole test, the test for eligibility under 101. And they said that the concept of hedging in this particular case, again, the subject matter of the patent in the Bilski case, is an unpatentable abstract idea, just like, again, the algorithms that were at issue in the Benson and Fluke case, like we previously saw. And they stated that there's no categorical exclusion of business method patents. Really, that's in theory. I don't know if anyone out there deals with business method patents and patentability issues there. I think you would say, well, it feels like an uphill battle, but it really is no categorical exclusion. Okay, so the big one, Alice v. CLS Bank, which was handed down in 2014 by the Supreme Court, and the subject matter in that patent was maintaining account balances, updating account balances, transactions were involved, and carrying out transactions at the end of the day on real accounts. So it was really a type of intermediary accounts trying to reduce the risk that only one party would perform an exchange on the real accounts. And CLS Bank has millions, trillions of dollars every day using this particular invention and subject matter of this invention. But usefulness and whether or not CLS Bank actually used it is not the issue here. The issue is whether this subject matter was an unpatentable abstract idea. And in Alice, the Supreme Court then unanimously invalidated the patent because they determined that the claims cover an abstract idea. And in the opinion, they laid out a two-step test. So step one being, first, determine whether or not the patent is covering an abstract idea. So that begs the question, well, again, what is an abstract idea? And the Supreme Court let out several examples of what they saw or thought or had the opinion were abstract ideas. So, for example, fundamental economic practices. So what we've been seeing in some of these other cases with moving money around, hedging loss, those types of issues. Methods of organizing human activities, an idea itself, again, not too helpful, and also the mathematical relationships and formulas like we saw in some of the cases in the 70s and 80s that we previously reviewed. But they also stated that, we're not going to delimit the precise contours of what an abstract idea is. We're not going to define every single possible subject matter that could fall under the abstract idea category. And also in the case, they laid out the second part of the test, which is determining whether or not, if it is an abstract idea, if it contains an inventive concept. And again, we'll get back to that in that section of the test in more detail as we go through. So now moving on to the ramifications of the recent certiorari denials. I can hardly say that word. It is always a jumble, so I'm just going to refer to it as cert. I think everyone understands what I'm saying, so I'll continue to use that nomenclature moving forward. So just a little background for anyone who may not be familiar with what is a writ of cert. Why would a party be petitioning for this at the Supreme Court? So any party who is not satisfied with the decision of a lower court can petition the U.S. Supreme Court to hear their case via a writ of cert. And of course, the Supreme Court is not under any sort of obligation to hear any of these cases. Usually only tends to do so if it falls under one of these three categories. For example, the case has national significance. The case might harmonize some conflicting decisions in the federal circuit courts, or the case could have precedential value. And typically, the Supreme Court will hear cases that have been decided in either the appropriate U.S. Court of Appeals, for example, the Federal Circuit, or the highest court in a given state, and that's if the state court decided a constitutional issue. And 4 out of the 9 Supreme Court justices must vote to accept a case. So just a little bit of stats that we kind of Frankenstein together, so take these with a grain of salt, but just to give you an idea of how many cases, or IP cases generally, does the Supreme Court even look at on a yearly basis. And in the last 80s, 90s, 2000s, Supreme Court was taking about 3 to 4 IP or intellectual property cases per term. Again, not strictly patent, but IP cases. And at that time, that was about 4% of the cases that the Supreme Court was taking up. Now, if we fast forward to the last year or so, or last few years, we're now back up to about 8 or 9% IP cases before the Supreme Court. And again, as it states here on the slide, one of the bigger years or record-breaking years was the year that Alice was handed down, so in 2014. So I am now going to pass off to my colleague David Lindner briefly, who's going to discuss some of the recently denied petitions for cert.
Thank you, Andrea. So just wanted to kind of frame everybody's perspective here. And so in the presentation that we put together, and I think that you'll have access to later on at the conclusion here, we have a few slides that have tried to correlate and collect a number of cases that for which cert has recently been denied. And so what you're going to be able to see here as you go through it is that there's been a considerable amount of activity amongst litigants over the past 5 to 7 months to continue briefing the Section 101 issue in an effort to receive clarity or further guidance from the Supreme Court. In a review of these cases, you're going to see that this is affecting all major technology areas. It's software, it's pharmaceutical, and it's business methods. We're going to dig into some of these cases later on as the presentation continues, but one that I did want to highlight is the Cisco Systems case, which is at the top of the screen right now. This is a case that's worth highlighting because just yesterday the Supreme Court again denied cert for another one of these 101 cases. So this case involves SRI's asserted claims that were directed to computer automated methods of collecting and analyzing data in a computer network to detect suspicious activity. Now, for those of you that have been following these abstract idea lines of cases, this might sound eerily similar to the electric power group versus Alstom case, where the claims were directed to collecting information, analyzing it, and displaying certain results of the collection and analysis. In that instance, the claims were found to be patent ineligible. And in fact, this is exactly what Cisco argued and what Judge Lurie's position in his dissenting opinion. Judge Lurie found the two cases to be hardly distinguishable. Nonetheless, the majority concluded that while SRI's claims recited generic steps, they were an improvement in computer networking technology that solved a specific problem. As a result, the majority found the claims were not abstract at all under Alice's Step 1. Now, ultimately, at the end of the day, I think it's probable that the Supreme Court did not grant cert on this case because there was no dispute about the legal rule that was being applied. Everybody agreed Alice was the proper application to be followed here. It's just that Cisco didn't like the result. And the fact that just boils down to a fact-based analysis that doesn't fall under one of the three categories that Andrea mentioned before, where the Supreme Court might pick up cert. However, the interesting thing to note here is that just prior to Cisco filing its petition with the Supreme Court, the USPTO issued its October 2019 subject matter eligibility update. And in fact, the PTO specifically addressed the Cisco case, and they reconciled the different outcomes in Cisco and electric power because the claims asserted in Cisco did not recite a mental process and were therefore outside of Alice's Step 1. This is actually a different position than the majority in the Federal Circuit came down with. But the PTO's view of electric power was that it did recite a mental process that could be formed in a human mind and was therefore abstract. So, I mean, it's a little bit confusing here that the PTO is taking a position slightly different than the Fed Circuit, and it kind of begs the question where you have claims that are involving the use of a computer to collect and analyze data. Only time will tell if we're going to run into a situation where this now case-specific distinction is going to impose even further difficulties in trying to determine what is patent-eligible subject matter. So we just wanted to highlight this case given the fact it was literally just denied cert yesterday. So with that, I'm going to turn it back over to Andrea, and she's going to address the Berkheimer case.
Thank you, David. So as David said, I'm going to dive into Berkheimer a little bit, some of the cases that came after Berkheimer, and a couple of those are also cases that the Supreme Court recently denied cert on. So in the Berkheimer case at the Federal Circuit level, this case came out, I think it was February of 2018 was the Federal Circuit's decision. The patent suit in that case is relating to processing and archiving files in a digital asset management system. So you see processing, archiving, digital system, kind of automatically think, okay, 101 issues. And in the lower court, the district court, they granted summary judgment of invalidity on some of the asserted claims based on 101. There were some other claims that they had held to be indefinite, but really we're focusing here on the 101 issues. Berkheimer wasn't happy and appealed to the Federal Circuit. So at the Federal Circuit, when reviewing Alice Step 1, the court found that the claims were directed toward the abstract idea, parsing, comparing, storing, and editing data. However, when moving on to Step 2 of Alice, the Federal Circuit found that there were questions of fact that were underlying patent eligibility in this particular case and that there could be in other cases, which made summary judgment inappropriate in this particular case. Now, in case you need some reminder, the summary judgment is only appropriate when there's no genuine issue of material fact, and the court found there's questions of fact, so that wasn't appropriate at the district court level. Judge Moore wrote that whether claims cover only conventional activities requires some sort of factual determination. So it could be impossible if this issue is presented to conclude that claims are ineligible at the summary judgment stage. Now, she did also go on to state that nothing in the Berkheimer opinion was meant to give question or cast doubt on any of the previous 101 decisions in the last however many years. Where there's no genuine issue of fact, this isn't an issue for people. But if there is, then summary judgment and the analysis of summary judgment needs to be considered with respect to those factual disputes. But despite these words of Judge Moore that none of the previous 101 decisions should be cast into doubt, we have seen a sharp decrease in early ineligibility determinations in litigation. So just as an example here, this data comes from RPX Corporation, and they update their pre- and post-Berkheimer data on a quarterly basis. So the most recent is from October of 2019. I expect they'll likely be updating through the end of 2019 in the near future. But I think we see here, if you look at pre-Berkheimer, the decisions invalidating claims, pre-Berkheimer was 68%. And we see a complete switch for the most part in terms of the majority. Post-Berkheimer, now only 44% of ineligibility challenges are being ultimately found invalid. So more maybe interesting is looking at it by litigation stage. So here we have a breakdown of Rule 12 versus summary judgment stage. So Rule 12 dismissals, generally, for the most part, earlier on in the case, right? You haven't had too much discovery, not a big record at that point. And there we're seeing previously, pre-Berkheimer, 70% of patents being invalidated at the Rule 12 dismissal stage, as compared to now, post-Berkheimer, only 46%. So again, the majority now of these patents being held not invalid patent claims. Looking at summary judgment, pre-Berkheimer, we were looking at 59% of patents invalidated at that stage, whereas now we're looking at only 36%. So despite Judge Moore's words, I think that there is certainly an effect post-Berkheimer on these early ineligibility determinations. So another case, and it was in the chart that David just discussed, Selspin case from the Federal Circuit in 2019. This is another case that was recently, I think about a month or so ago, denied cert by the Supreme Court. And this particular case was at the motion to dismiss stage. And there the district court found that the patent in suit was directed towards the abstract idea, again we're seeing acquiring, transferring, publishing data, under Alice Step 1. When moving on to Step 2, the district court found that the claims did not recite an inventive concept, and did note Selspin's argument that there was a factual dispute as to whether the elements were well understood, routine, and conventional. But the district court decided to not take up that particular argument, and there were two main reasons for that. The district court first stated that, Berkheimer was a summary judgment stage case. This is a motion to dismiss case, so we don't need to look at it. We don't need to follow it. And second, they also stated that Selspin failed to identify a portion of the patent in suit spec that described the inventive concept that they had alleged in their complaint. So when moving up to the Federal Circuit, they agreed that the patent in suit was directed towards an abstract idea, so checked off Step 1. But then disagreed with the district court Step 2 analysis and their discounting of Berkheimer. Selspin had actually cited allegations in the complaint in accordance with ATREX. So that's a previous case where it was held that, citing to allegations in a complaint with respect to these particular issues is enough. And the Federal Circuit held that despite the failure of Selspin to cite to anything in the specification, its reliance on specific, plausible, factual allegations about why aspects of its claimed inventions were not conventional was enough to at least raise a factual question that made dismissal at that particular stage in the case improper. Another case, MyMail, that came after Berkheimer, dealt with a method of modifying toolbars. The term toolbar had previously been construed, but not addressed in this particular case. Again, the court found that Step 1, it was an abstract idea. But when moving to Step 2, the court found that there were still issues with respect to claim construction, as to the construction of toolbars specifically, so that the district court erred by not resolving the claim construction dispute before moving on to eligibility. The Federal Circuit said, we're not going to deal with the claim construction, we're going to remand it back, but this needs to be dealt with before anything else. Judge Laurie did dissent and stated that, I don't care how claim construction comes out, the claims at issue are clearly abstract. There's some potential pitfalls after MyMail. I think I'm going to just highlight them. If you want to potentially avoid a motion to dismiss as a patent owner, it may be wise, depending on your case strategy and how your record has developed at that point, to raise claim construction issues early on in the case. It may deter and have the district court determine that they will not determine any sort of eligibility issues until claim construction is resolved. So now I'm going to pass the mic off to David again, who's going to dive into the Athena case, one of the recent cert cases, as well as some other issues.
Thank you, Andrea. So Athena is one of the cases that was in our chart, probably one of the more recognized and discussed cases as of late. And just very quickly, before we dive into the Federal Circuit's denial of en banc rehearing, which is where a lot of Athena discussion is coming from, just to quickly highlight what this case entailed. It was the patent in suit related to methods for diagnosing neurological disorders by detecting antibodies in blood and correlating those to a protein related to a specific disease. The district court found the claims were directed to a natural law and lacked inventive concept, and the Federal Circuit affirmed. So let's take a quick look at how the Federal Circuit affirmed the decision here in the first instance. So applying the two-part test, the majority found the claims recited only a natural law together with standard techniques for observing it. And while Athena argued the claims were directed to an innovative laboratory technique, it could not point to any innovation other than its discovery of the natural law. So this argument for an application of an innovative laboratory technique is an important point, because the Federal Circuit has made distinctions in the past that claims that recite a natural law and conventional means for observing it are not patent eligible. But if you actually have an application of that natural law, it is patent eligible. So Athena was trying to make the argument that they were falling into that latter bucket and that their claims were patent eligible, but because they couldn't point to anything other than their discovery, the majority was unpersuaded by that argument. Ultimately, I think that the majority was, felt very constrained by some language in Mayo, and that is that in Mayo, the Supreme Court set forth this principle that a relationship between biological material and a disease is a law of nature. And so that's where the majority kind of fell into this bucket of, well, Athena's claims are directed to a law of nature, and you're not going to pass step one. Athena did try to argue as well for patentability under step two, but in that instance, even the unconventional steps that they were trying to recite, the majority refused to give any patentability credit to, and it's a result of another Federal Circuit case, the genetic text case from 2016, where they said that inventive concepts cannot be furnished by an unpatentable law of nature. So, even had Athena gotten to that point, they would have still, fallen into the step two, trap and resulted in unpatentable subject matter. Judge Newman issued a dissent, and it was pretty straightforward that she was taking the position that our 101 decisions, the Fed Circuit's 101 decisions, are drastically inconsistent. She further took the point that, in her view, the claims were not directed to this correlation of biological material and diseases, which is where you fall into the Mayo nature of law exception, but rather that they were just directed to a diagnostic method and should on their own be patentable. Judge Newman also pointed out that there's a disincentive to develop new diagnostic methods. We're going to see this come up again in a second in the en banc review, but the trouble that these laws of nature and these diagnostic patents are facing really gives no incentive for companies to go out and actually innovate and invent to try and come up with new diagnostic methods. So that brings us to the en banc review. As noted here on the slide, there were 8 different opinions. Unfortunately, we don't have time to dive into each of them, but I would highly recommend, if you haven't looked at the various decisions, to do so. I did want to just take a moment or two to highlight a few aspects to kind of illustrate the different understandings of Mayo and how it's being applied. Judge Laurie, in his concurring opinion, which was joined by Judges Renya and Chen, wrote that we are bound by the Supreme Court's decision in Mayo. If I could write on a clean slate, I would write as an exception to patent eligibility as respects natural laws that only claims directed to a natural law itself. For example, E equals MC squared or force equals mass times acceleration. But I would not exclude uses or detection of natural laws. Judge Dyke also wrote in a concurring opinion that he recognizes the value of Mayo and Alice as being valuable and effective at invalidating overly broad claims that would not otherwise be accomplished by sections 102, 103, or 112. Interestingly, though, in Judge Dyke's opinion, he also states that he didn't believe that there was any problem in implementing the abstract approach of Alice. His concern is more with implementing the natural law approach that's recited in Mayo. So even though we have other litigants and other cases that are trying to seek clarification on even Alice's two-step approach, Judge Dyke is completely comfortable with that approach. It's the law of nature approach that's more problematic to him. One final point to highlight here was in Judge Moore's dissent. Judge Moore noted that since Mayo, the 8 separate times that diagnostic patent claims have come before the court, the claims have been invalidated every time. As such, Mayo has turned into a per se rule that a diagnostic kit and techniques are ineligible of receiving patent protection. You know, this is, I think, really problematic because these diagnostic kits and techniques, as Judge Moore highlights, are precisely the type of innovation that the patent system should promote. They help reduce medical costs and early disease detection. I think it's just an issue of whether or not these claims are claimed narrowly enough. But as we've seen in the 8 cases for diagnostic claims in the past, it doesn't matter how narrowly you claim it. You know, they're really being viewed as you know, per se ineligible, is, you know, just for the fact that they are directed to diagnostic claims. Under Judge Moore's reading of Mayo and even under Section 101, she actually would have come to a different outcome, and she thought that the claims in Athena were patent eligible. She thought that they were significantly different than those in Mayo. The claims recite a specific method of applying a natural law in diagnosing patients that have never previously been known, rather than the high-level claims that were presented in Mayo that simply instructed doctors to apply the laws and then treat their patients. Ultimately, we do know that obviously all of the cases that were included in our chart that have already been decided have cert has been denied, and there's, I think, still 2 pending cases. I'm not too hopeful that we're going to see a grant of cert in those either. So it does beg the question of where do we stand with respect to these diagnostic patents. And I think, you know, in view right now, even though everybody's desiring, you know, further guidance, the Supreme Court has said what they have to say, and we are left in the situation that these diagnostic patents are going to face a steep, if not per se, uphill battle of patent ineligibility. Just very quickly, we have a couple slides in here on some takeaways for litigants. I'm not going to kind of go into those. I think they're very self-explanatory, you know, once you review the presentation. And we did want to also finally note that there are some avenues in which the district courts are trying to address the 101 issue up front. Judge Gilstrap has issued a standing order requiring if any litigants are going to raise a 101 issue that they do it very early in the case. It has to be done within 45 days of receiving infringement contentions from patent owner, and it has a number of details that are required so that you, as a challenger under our 101 issue, are putting all your cards on the table up front very early in the case. And additionally, the Northern District of California has amended or added into their local rules that invalidity contentions, when they're served, have to also include any 101 arguments. And so, again, trying to raise this issue up front and get everybody, on the same page. If this is going to be decided, let's decide it quickly. With that being said, I will let everybody know that the second CLE code is Alice, and I will then turn it over to my colleague, Gang Chen, who is going to address prosecution issues.
Hi, everyone. And my name is Gang Chen. I'll be talking about prosecution issues. Kenda and I actually will be talking about prosecution issues. I'll get started by giving you some sort of introduction on the various guidelines that the patent office has given to us, patent prosecutors, given to patent examiners, which we study in order to have a more effective patent prosecution process in dealing with 101 rejections or in drafting cases, for example. So as you just heard that there are many 101 cases from the Federal Circuit and the early cases from the Supreme Court that provided pretty inconsistent guidance in terms of what the rules are for Section 101. And Supreme Court, since Alice hasn't taken on any Section 101 cases, and all the guidances that the court, us as a patent prosecutor and the patent office are getting from these newer Federal Circuit cases, and they're sort of inconsistent in the way that they interpret the Alice case. So the patent office is confused as well, so you can see from their reactions. So what they did, the patent office, is to come up with a series of guidance for their examiners. And they keep updating those guidance through the years when new Federal Circuit cases are decided. So the earliest one was the 2014 interim guidance. That was right after the Alice case. So what was done over there was that they basically recasted, the patent office guideline recasted the rule that was given in Alice. Then through the later years, in 2000, for example, in 2015 and 2016, there are some updates on this issue when some new Federal Circuit cases were decided. And the major revision was done just last year, actually January last year in 2019. There was a new revised guideline that was given from patent office to their examiners, which sort of maintained the Alice steps in testing patent eligibility, but at the same time made some clarification and revision on the steps, especially one of the steps for better and more clear guidance to the patent examiners. So these are the guidelines that we as a patent prosecutor, we sort of study, right? So as a daily practice of drafting applications and dealing with rejections and talking to examiners. So we follow this very closely. And there are also some other documents that the patent office issued during the course of the past several years to their patent examiners in the form of memos. And those memos were important because they summarizes some of the cases that were decided by the Federal Circuit during the past few years. I will go through a couple of them later in this slide deck, but those are also the memos that we look at very closely. Those are the ones that contains many languages and arguments that could be used in patent prosecution in response to the office action, in rejections, to try to tell the examiner that, hey, if you follow those memos, these claims should really be patent eligible, for example, right? And also, by looking at those memos, that would give some insights into patent drafting process, like what should be included in a patent application, how detailed description of particular embodiments needs to be. So these guidance are all online, and if you go to this website that is listed over here, you can see all those guidelines. And some of them might be archived. I think maybe some of those memos you have to go through a few layers of navigation in order to find them, but they're all there. So let me just jump into some of those guidelines and memos. Let's just start with the 2014 interim guidance. So this is right after Alice was handed off by the Supreme Court. And basically the memo, the guidelines just outlined, recasted what the Supreme Court said in terms of the two-step test for patent eligibility. Now, you can see here, step one, there's step one, step two, and you see step two has two portions, A and B. But step one is really just, the statutory, description, right? So this is section 101, which basically says that everything is patentable under the sun, as you hear from previous portion of the presentation. So, and step two now start to carve out exceptions under Alice. So those are the two steps that are used in Alice and which are restated here by the guideline from the Patent Office as the steps to determine whether something which is kind of looked like patentable under statute should not be given a patent for. Basically, there are two parts of that step, which is step two. Step A says the first decision is to look at the claim and decide whether the claim is directed to some judicial exceptions, right? So those include natural law of nature, natural phenomena, and abstract idea. As you can see, and there's not much guidance actually in the document that the Patent Office was given, because just as what Alice was, was happening in Alice's case, where there's really no definition of any of those patent eligible categories. Law of nature, natural phenomena. There is even question of what's the distinction between law and nature and natural phenomena, for example, right? And the Supreme Court decided not to give a definition or make a distinction. And the abstract idea was casted as a few examples, but there was really no definition of what abstract idea would be, and the Supreme Court pretty much just decided not to define it. Right? And as you know, that every patent claim or every patent is an idea, right? So the question really is to what extent that the idea that was, focused on or the claim is directed to is abstract, and to what extent they are not abstract. So it was not very well defined. But nevertheless, in that step, you have to make that determination, basically. That's according to the Patent Office guidance. But then in step two, part B, then you start, if there's an abstract idea, then the decision, next step is to determine whether you have any other elements in the claim that provide significantly more to the underlying abstract idea. Again, this sort of gets into this inventive concept, which is sort of like, it's a novelty inquiry pretty much. So you can see that Alice, as well as the Patent Office, in interpreting Alice, sort of poured, inventiveness or poured novelty into the 101, section 101 analysis, right? So that's what, is causing a lot of confusion. So this is a guideline that we had to deal with for many, many years, right? And until So we basically just look at those steps and try to come up with arguments or try to draft applications that, or tasks that according to those two steps. And then the major updates came last year where the patent office eventually started to put more light into those steps. And by the way, these are the patent office guidelines, right, as we know, and they are not really the court decisions. So just make sure that, we don't really know what the court thinks, right? Because the court has all those cases that are inconsistent, and the patent office try to interpret those cases. And until we see another Supreme Court case, for example, which harmonizes everything, we probably won't know what the court thinks about, those guidelines. But anyway, so in 2019, in this new guideline, there was two major updates, basically. The first one is the patent office try to define, give a better definition of what abstract idea is. So they basically casted, whatever abstract idea would be falling into those three categories that you see over here. Mathematical concepts, mental process, and methods of organizing human activities. So, and that's progress because, at least those three things here listed here, groups, at least they're more concrete than just saying something's abstract idea. So, so this is the first major improvement. Now, then what the patent office did, this new guideline, is to look at step 2, right? Remember that there's a lot of consistency in terms of what constitutes this concept of, something significant more than the abstract idea in a claim. And what is the question about whether the claim is actually directed to abstract idea, because as I just discussed, every claim has an idea, and there might be multiple ideas inside the claim. The question is, what does it mean by the claim is directed to a particular idea? So what the patent office did is to give some clarity on this, and they take three steps 2A and separate them into two different portions, prong 1 and prong 2. And what they said in prong 1 basically just says, whether the claim, the first prong 1 is to determine whether a particular claim include or recites abstract idea, right? One of those three from those three groups. If you have 5 elements in a claim, for example, one of them is recite those idea, abstract idea, one of them, then prong 1 would pass in terms of patent ineligibility, right? So the claim would recite one of those categories. And then prong 2 basically is to deal with whether the claim is directed to the directed to any abstract idea in old step 2, old step 2A. Basically, now the question is whether there are contents or elements in the claims that are that integrate whatever recited abstract idea into practical application. So now this concept of practical application it's still not clear, but it's better than the question of whether something is directed to abstract idea, right? So, and Kent later will give you an example on how patent office sort of is using this particular step, and then what constitutes a practical application. So, and the next slide is just a kind of detailed description of the step that you can probably find online, and you can take a look at them more closely. There are a couple of memos that I mentioned. Those are the memos that describes the court, the new circuit, the federal circuit court cases. So those are the ones that we sort of use in our patent prosecution process to make arguments to fight against rejections and to use as a guideline to draft our applications. And the slides are here, so you can kind of take a look at those, and you can actually go back and take a memo as well. Those are typically examples of what sort of arguments against rejections that you could make with respect to Alice step 2A or 2B. All right, so now I'll turn over to Kent, who will give you some examples that can apply these new guidelines, and then some other aspects of patent prosecution.
Thanks very much, Gong. So just to take over from Gong regarding the Patent Office guidance we're getting on how you handle Alice, it all relates back to what Andrea and David started talking about, and it's a good idea to understand what the basic rules are and what the Patent Office changed is. So just to reiterate what Gong mentioned, the basic idea when you have and I'll stick with abstract subject matter as opposed to natural phenomena, just because it's easier to focus on one area. But when you start off, the analysis is easy. One, is there a statutory category mentioned? Does your claim deal with a process, manufacturer, composition of matter? That's usually easy. Then the Alice case says, okay, well, does this claim recite an exception, a judicial exception, i.e. abstract subject matter? And under Alice, the next step would be 2B, which would be, okay, well, if it does recite abstract subject matter, does the claim show significantly more on an inventive concept, this sort of miniature 102, 103 prior art analysis? Patent Office took a step back and said, you know what, it's just too difficult to get through 2B. So let's change 2A into a two-part or a two-prong aspect. The first prong is something recited? Reciting can mean setting forth or describing one of those three categories I mentioned: math concepts, mental processes, certain methods of organizing human activity. But you can avoid 2B, the significantly more miniature prior art review, if you can show, and say it's actually not directed to this judicial exception of abstract subject matter. You can say it's not directed to it if you can show that the judicial exception is integrated into a practical application. So I want to walk through an example of what that means. Again, this is what the Patent Office is using. It's not what the courts are using, but just getting something out of the Patent Office to get to the courts is our first goal, so we'll go with it. All right, so in the examples that you can find on the Patent Office website, I'm going to look at example 45 here and walk through claim 1, which is shown in red because it indicates things which are abstract, and then claim 2 and others later on, which are considered to, under prong 2, to be integrated into a practical application. So applying the steps of Alice to this claim deals with a machine that controls injection molding process. I think if you look at the details, it has to do with creating skateboard wheels in some sort of curing process. Is there a statutory category? Okay, it's a controller, therefore it's a machine. It passes step 1. So 2A would be, okay, does it recite a judicial exception? And you look at each judicial exception, but again, we're just dealing with abstract subject matter for time purposes here. 1A says, repeatedly obtain measurements of a temperature of a mold. 1B says, calculate an extent of curing completion of this polyurethane in the mold using the obtained temperatures and the Arrhenius equation. And C, determine the extent that the polyurethane has cured as a percentage. So looking at the Patent Office analysis, step A is mere data gathering. Step B, calculating, well, that implies mathematical concepts. So it's either set forth or described. And also step B calls out expressly the Arrhenius equation, which for those who are keeping score, the Arrhenius equation was part of the Diamond B. Deere case. You can see the Patent Office didn't go too far from its roots when it came up with this example, as the Arrhenius equation was involved there as well. And C, determining is another step. So are these things directed to a judicial exception? You have to say, yes, it recites a math equation and possibly even gets into mental calculation, use of the Arrhenius equation in your head, you could calculate things possibly. So is there any integration of these steps, A, B, and C, into a practical application? Not really, because it's a generic controller that's cited here. So the controller configures to do A, B, and C. They haven't cited any specific machine, and it really is at most talking about the environment in which this equation and calculations are done. But then if you go to claim 2, dependent claim 2, it adds a new step, step D. send control signals to the injection molding apparatus. Once the polyurethane has reached target percentage, the control signals instructing the apparatus to open the mold and eject the molded polyurethane from the mold. And what you're not seeing with this example on your slide, of course, is all the background which makes up for the mock specification that this claim comes out of in the case. In the specification, the imaginary specification that these claims are associated with in the Patent Office site, there are definite technical improvements to making sure you cure this polyurethane in this molding device in a certain temperature. So here, D was indicated in the examples from the Patent Office, sending control signals to control a specific device here, the molding apparatus. That was enough to go ahead and say, okay, that's integrated into a practical application. So under the Patent Office rules, this would be eligible. Under 2 would be eligible, Claim 1 would not be eligible. It gets a little more complicated with 3. 3, again, refers back to the ABC we talked about before, which was not patent eligible as it was directed to abstract subject matter. And here it adds the controllers connected to a means for temperature measuring that repeatedly measures the temperature of the mold. So they've modified essentially step A from Claim 1, repeatedly obtaining measurements. They haven't really included these means, what it's doing. It's just mentioning that it's there as part of the measurement step. So would this pass muster under the Patent Office guidelines? And the Patent Office said yes, not so much because it integrates anything into a practical application, because really all we've done is mention from step A before, measuring temperature multiple times, what it is that's being used to do it. Instead, the rationale that the Patent Office would allow this claim to go through on is that, hey, you know what? It's a significantly more, it's a 2B significantly more because, and again, you don't have the benefit of the description, but the imaginary description that goes with this Claim 3 says that there's a particular type of thermocouple, a specific device. It's not normally used to measure temperatures of molds, and it's being used here. So on that basis, on the basis that you're adding significantly more, that you're changing and you're coming out with a more effective machine that processes and makes transformation of this polyurethane mold, this claim is allowed. Lastly, Claim 4, again from the same pseudo-specification as shown in the examples in the Patent Office website. Controller for injection molding. Here the steps are send a control signal to regulate the injection of the mold, polyurethane into the mold, repeatedly obtain the temperature measurements, compare the temperatures to a target, and maintain temperature within 2 degrees of a target temperature by sending a control signal to selectively heat or cool that mold. Because, again, there is discussion in the specification, which is an important thing to understand both from the case law and from what the Patent Office is telling you, that there's an improvement, a technical improvement being achieved here. Step D actually helps to integrate under prong 2, saves this claim, makes it eligible. So again, there are multiple, there must be over 40, I think there are 47 examples in the Patent Office, and the change that happened in 2019, which allowed a integration of a judicial exception with a practical application to try to bypass the 2B analysis, is very important. Why is it important? Because under 2B of Alice, you have to show that whatever your significant more improvement is, can't be well understood, routine, or conventional. Under the Patent Office rules, where you can show integration, you don't have to deal with any showing that it's new, that whatever your integration is with the practical application is new. You can skip that altogether, and that essentially broadens what's considered eligible in the Patent Office. So how has the PTAB dealt with this? Well, PTAB provides on the site, there's a link below, which I find very useful, and I recommend it to you, a number of decisions, which it considers informative decisions or precedential, indicating how the PTAB is going to apply it. The PTAB is going to, in 2 cases here, Ex parte Smith and Fouts, found that there was a prong 2 integration of a otherwise judicial exception into a practical application. Ex parte Smith is interesting. We dealt with that case. That was a case where it had to do with trading operations on an electronic trading floor where you needed to get in non-electronic trades. and involved adding a delay, which was determined to be a technical improvement. The ex parte Fouts case is an improvement. It was a case that specifically recited a formula for how you calculate how a coil operates in an MRI device, and it did address a technical problem that had to do with actual operation, so that was considered a prong 2 bypass that made it eligible. And of course, there are other ineligible examples they provided. One had to do with providing org charts or operational chart generation with no particular computer other than a general server. There was also a golf club fitting method in ex parte Kamizuka. There, it simply measured how someone swung their golf club, used tables, and provided suggestions of how to improve your selection of a club. Again, no mental processing, judicial exception, couldn't get out of it. There are a number of procedures, CBMs, covered business method reviews, IPRs, and post-grant review proceedings that you can use to try to get after 101. 101 really can only be attacked in a PGR or a CBM. But there have been cases, including, going back to the slide here, this Wells Fargo versus USAA case had to do with essentially remote deposit capture of checks when you deposit a check through your phone. There are technical aspects of that. USAA sued Wells Fargo and recently won several large judgments, but along the way, Wells Fargo filed some CBMs to try to show that they weren't technical, that there was a 101 issue. PTAB actually denied institution of these CBMs, a number of them, because there was insufficient showing. Other examples are provided. So moving along quickly, because we are coming towards the end here, there are some interesting statistical charts I'll let you go through. Not a lot of CBMs and PGRs in the entire life of these proceedings, but a number of PRs. The institution rates are interesting. This is a little misleading because it's combined, so it shows CBMs, IPRs, and everything else. But institution rate is 60% or less recently, and seems to be dropping. And there's also a listing of the types of technologies that these proceedings are raised in. CBMs in particular, if you look at the fiscal year 2019, it's dropped to 22 CBMs in the year from 47 a couple of years before. So that seems to be a less used procedure. So just really quickly, we've talked about kind of two prongs, not to overuse that word, of analysis, and we have the courts, and they're not doing much right now as they've denied cert. We have the Patent Office, which is scrambling kind of in a delay mode to try to get what has been through the courts put down as guidelines. What's going on with legislative reform? I'll let you look at these slides, but essentially what's happened is in 2019 there was a lot of activity from the IP subcommittee to draft legislation that would remove 101 from being what it is right now, but essentially broaden out the ability to get a patent through and only have possibly specific designated areas that are not patentable. Also, there's unfortunately a very recent report that the head of the committee, I think it's Senator Tillis, has decided that they're going to table any further legislation on this for 2020, so it's likely not much will happen. It was a bipartisan group. They came up with some suggestions. It wasn't agreed on by everybody during the comment periods, but that's really all we have time for right now, so I'll let you read the rest of the slides, and of course, feel free to ask us any questions.
Well, thank you, panel. Just for those of you who need to run, our last CLE code word is development. And with that, we will take questions for those of you who have time to stick around and listen to our panelists discuss any of the issues that they've discussed, either in terms of litigation or prosecution or recent developments in the legislative history, which Kent went through quickly at the end. Well, let me start it off with a question for David, actually. So, David, in view of the fact that the Supreme Court has not weighed in after Berkheimer and the Athena decision, what do you think it will take?
Well, unfortunately, I think it's going to take some action by the legislature. I think that multitude of opinions that came out of the Athena case really highlight how much even the Federal Circuit is looking for additional guidance. And if the Athena case wasn't enough to push the Supreme Court over the edge to kind of pick this up, it was a case that did, I think, mirror nicely with the original Mayo decision. And so it would have been an opportunity for the Supreme Court to go back and revisit their initial rulings in Mayo, which kind of started to, at least from the laws of nature aspect, initiate some of these confusing and irreconcilable decisions. If that case wasn't enough to do it, I'm not certain if there's going to be a case that they're going to want to take up. I think they've said what they wanted to say on it, and if there's going to be a change, it's going to come from legislature.
Thanks. So, Andrew, let me follow up with a question along those lines. In view of the fact that there is some legislative efforts to change the patentability requirement, do you think that's influenced the Supreme Court at all in denying some of the petitions that we've discussed?
Thanks for that question, Gus. I mean, it's possible, right? I'm not aware of any quotes, articles, opinions that have come out by any of the Supreme Court justices saying that that's, what they're waiting for. They're waiting for legislative reform to take place before they make any sort of determination or take up any of these cases. But I do think it's possible. I know one of the en banc opinions by Judge Moore in the Athena case, she did mention, certain things about the IP subcommittee hearings. Seemed like she was a little bit influenced by some of the things that were said there. So it's definitely, it's out there. I think at least, the Federal Circuit justices are aware of it. So I wouldn't say it's improbable that the Supreme Court justices are considering that as well.
Thank you. So we turn it over to our other team. In view of the current case law and the USPTO guidance that we have, that we know is the case law is somewhat inconsistent, and the PTO guidance is only guidance for practitioners, not necessarily for the courts. But in view of what we have, what do you think that companies or inventors should be providing their patent attorneys in order to draft the strongest applications?
That's an excellent question. I think there has been some guidelines just from the original cases that said the more you can put your technical advantages in writing into the specification itself when you draft a case, the better chance you have of getting around a rejection and making come up during prosecution, and also to preserve validity when claims go to trial. What I would suggest people have their inventors provide would be specific technical implementations and a specific description as to what the advantage is technically of what was done before. And I emphasize the term technically only because there are many financial technology areas where there are procedures or client-facing algorithms that until the implementation details are in there, they're at great risk of being rejected as an abstract subject matter. So the more you can put in writing into the specification, which is kind of contrary to how we were raised to draft applications. You don't want to put requirements in there for advantages. But now, with 101, it's almost a requirement.
Thanks, Ken. Following up along those lines, so you've indicated what would be useful in terms of drafting new applications. I know that companies have a significant, or some companies probably have a significant number of applications that were filed prior to Alice. What can companies do to try and overcome 101 rejections for those applications that were drafted before we had any guidance?
Well, that's kind of the quagmire we're in right now with many cases. A lot of valuable IP, which for years was presumed to be valid and not direct, didn't have a 101 issue. 101 rejections came out of whole cloth based on this case law. And so what we end up doing is we try to find the technical aspects. Is there anything in the specification we can pull off or pull out that will allow us to show some change that's affected to anything, whether it's a data format, sometimes converting data formats and moving them around in a certain way, even though it's ancillary to the direct idea of original claims, getting that in there just so there's a technical aspect and we can show improvement. Although ideally you would draft now to say what the advantages are, you can still try to show advantages even if it wasn't expressly stated. If someone of ordinary skill in the art can see there was a technical advantage, you can expand on that and argue that with the examiners. Interviews are a tremendous tool these days. As you can tell by what we've discussed today, the Patent Office is trying its best really to loosen up what's allowable so that 101 isn't really what's stopping things from being examined. So often a call to the examiner after scouring your specification to see what technical details you can add, trying to avoid just simple processors and memory and manipulation of data, but actually application of that, what's the final use of that data, somehow getting that in there, even if it's not so much expressed but implied, bringing that out can often get you just over the hump for 101.
Thank you. So we did have a question from one of our participants regarding the slides, whether or not they'll be shared. The slides will be emailed to all the attendees. And thank you very much. I don't see any other questions. That concludes our webinar. Thank you for attending.